I'm Eugene Calloway, 64 years old. And the day I finally stopped pretending my son loved me more than my money was, the day my real life began. It started on a Monday morning in early March. I drove myself to the credit union on Elm Street where I had banked for 31 years, walked up to the same teller who had helped me open my original account back when her hair was still brown, and quietly transferred my entire monthly Social Security direct deposit to a new private account my son knew absolutely nothing about. The new card was tucked into the breast pocket of my flannel shirt right next to my heart. I drove home, put a pot of coffee on, and sat down at my kitchen table. 40 minutes later, the back door flew open hard enough to crack the drywall behind it. My son stood in the doorway. His wife was 2 steps behind him. His face had gone the deep, ugly red of a man who believed the universe owed him a very specific explanation. He was gripping his cell phone so hard his knuckles had gone white. He told me, without a single hello, that his bank app had just flagged a failed automatic payment on the joint account. The mortgage payment on their house had bounced. He held the screen up in front of my face like evidence at a trial and demanded to know what I had done with the money. I took a slow sip of my coffee. I set the mug down on the table with both hands perfectly steady, and then I gave him an answer that made his wife grab the doorframe to keep herself upright. But before I tell you exactly how I dismantled the comfortable little world they had built on top of me, let me hear from you. Drop your city in the comments below and hit the subscribe button if you believe a parent's retirement belongs to the parent. I had moved into the in-law suite attached to my son's house 14 months earlier. My wife, Loretta, had passed away the previous winter after a short and brutal fight with pancreatic cancer. 3 weeks after the funeral, my son showed up at my door with a casserole dish and a proposal. He said he was worried about me rattling around alone in a 4-bedroom house. He said his wife felt terrible about me eating alone every night. He said the in-law suite had its own entrance, its own bathroom, its own little kitchen, and that I would have all the privacy I wanted. He said it was family taking care of family. What he actually said, much more quietly, was that it would be easier for him to help me manage my finances if we were under the same roof. I was 63 years old and I had just buried my wife of 38 years. I was not thinking clearly. I handed him access to my checking account because he made it sound like he was doing me a favor. My Social Security deposit every month was $2,412. My small pension from 30 years working as a claims adjuster for a regional insurance company added another $800. Combined, that was just over $38,000 a year flowing into an account my son could see and transfer from at will. In 14 months, I had received 1 bag of groceries every 2 weeks. Generic cereal, off-brand soup, whatever produce was marked down near closing time. I had watched my son's wife add a new granite countertop to the main kitchen. I had watched my brand new riding lawn mower appear in the garage. I'd sat in my small suite on Christmas morning listening to my grandchildren tear open presents downstairs, presents I was told I had helped pay for, while my own gift for my son was a drugstore gift set that still had the clearance sticker on the bottom. I am not a sentimental man. I spent 3 decades evaluating insurance claims for a living. I know how to document a loss. So I had been quietly documenting mine. I stood up from my kitchen chair and walked to the cabinet above the refrigerator. I reached past 2 cans of condensed tomato soup and a box of crackers and pulled down a thick manila envelope I had taped to the inside top panel 6 weeks earlier. I walked back to the table, sat down, and spread the contents out in a single, slow motion, like a man laying out a hand of cards. Inside were 14 months of printed bank statements with every suspicious transaction circled in red pen, every transfer to his personal account, every automatic bill payment drawn on my money, the riding mower, the countertop installation, 3 weekend hotel stays in Nashville, a recurring charge for a streaming bundle I had never been asked about and never used. I had run the total the week before, $41,000. In 14 months. Gone. My son stared at the papers on the table. His wife made a sharp sound behind him, something between a laugh and a gasp. He told me I was confused. He told me I was misreading normal household expenses. He said I had agreed to all of this, that he had explained everything to me multiple times, and that the fact that I did not remember proved exactly what he had been telling people for the last several months. He pulled out a chair, sat down across from me, and leaned forward with his elbows on the table. He spoke slowly, the way you speak to someone you have already decided cannot follow a fast conversation. He told me he had been discussing my situation with my doctor. He had spoken to my primary care physician at my last appointment, an appointment I had attended alone because my son had called ahead and introduced himself as my primary caregiver. The doctor had noted, based entirely on my son's description of events at home, that I was showing possible early signs of cognitive decline. My son had a printed letter from that appointment. He slid it across the table on top of my bank statements. He told me that if I continued this behavior, pulling money out of accounts without telling him, acting paranoid, making accusations against my own family, he was going to have no choice but to request a formal guardianship hearing through the county probate court. He told me a judge would look at my age, look at the doctor's letter, and place him in full legal control of every asset I owned. He promised that if that happened, he would make sure I was moved to a Medicaid memory care facility on the other side of the county. The kind of place where the carpet smells like disinfectant and you share a room with a stranger, and he would sell my personal belongings to offset the cost. His wife nodded along the whole time. She did not say a word. She just nodded. He stood up, folded his arms, and told me I had 24 hours to give him the new account number and sign a durable power of attorney document he had already had prepared by a notary. If I cooperated, we would forget this conversation happened. If I refused, he would be at the courthouse when it opened Tuesday morning. They left through the back door. He did not close it behind him. The cold March air blew in across the linoleum floor, and I sat there in my flannel shirt, listening to the sound of their voices fading across the yard, and I felt something settle over my mind that was not fear and was not grief. It was the same feeling I used to get sitting across from a claimant who had rehearsed their story too well. The feeling of a man who has already started building his countercase. I had worked in insurance claims for 30 years. I had evaluated over 9,000 individual claims during my career. I had testified in court as an expert witness on 11 separate occasions. I understood documentation. I understood the burden of proof, and I understood exactly how quickly a fabricated narrative collapses when you introduce contemporaneous records. But I also understood that my son had chosen his ground carefully. A probate court guardianship proceeding in this state can move fast when the petitioner presents a physician's letter and a pattern of claimed financial irregularity. The temporary order alone could freeze my accounts and hand him control before I could mount a proper defense. I needed two things before Tuesday morning. I needed an independent cognitive evaluation that could not be dismissed or explained away, and I needed an attorney who had spent his career destroying exactly this kind of financial predator. I went to my nightstand, opened the bottom drawer, and found the business card I had kept there for 4 years without ever expecting to use it. The card belonged to a woman named Agnes Whitfield. She was a certified elder law attorney who had spoken at a senior resource fair at our local library the year before Loretta got sick. I had taken her card on instinct, the same instinct that made me circle suspicious charges in red pen 14 months before I needed them. I called her at home. She picked up on the third ring. I told her my son was planning to file a guardianship petition Tuesday morning and that I had 14 months of documented financial exploitation and a fabricated physician's letter to discuss. She did not express surprise or sympathy. She said, "Be in my office at 7:30 tomorrow morning. Bring everything." I was there at 7:15. Agnes Whitfield was a compact woman in her late 50s with reading glasses permanently perched on her forehead and a desk that looked like organized chaos but from which she could retrieve any document in under 10 seconds. She read through my bank statements without a word, circling certain figures herself, occasionally tapping the page with her pen. When she finished, she placed the stack squarely on the corner of her desk and looked at me over her glasses. She told me the physician's letter was a problem, not because it was accurate, but because it existed. A single letter from a primary care doctor, even one obtained under misleading circumstances, gives a probate judge enough to issue a temporary emergency guardianship order without a full hearing. Once that order is signed, my accounts would be frozen. My ability to hire legal counsel could be challenged, and my son would have immediate authority to make decisions about my living situation. She told me we needed to neutralize the letter completely before the courthouse opened. She picked up her desk phone and made a single call to a neuropsychological testing center affiliated with a regional university hospital. She explained the situation to someone on the other end in crisp, precise sentences. When she hung up, She told me I had an appointment at 8:45 that morning for a full cognitive battery. She said the evaluation would take 4 hours and the results would be certified and submitted directly to her office by end of business. I drove myself to the testing center. I sat down across from a neuropsychologist named Dr. Hargrove, who had the careful, watchful manner of a person who has spent years listening to what people do not say. She explained the testing protocol without condescension. I told her I had spent 30 years reading policy language and writing detailed claim assessments, and that I had a reasonable expectation of doing fine. She smiled briefly and started her timer. The testing was thorough and unhurried. Memory sequencing, pattern recognition, verbal fluency, executive function tasks. At one point, they asked me to recall a list of 16 unrelated words after a 30-minute delay while I had been doing other tasks in between. I recalled all 16. I told Dr. Hargrove that I had trained myself to remember details in exact sequence because my job had once depended on reconstructing the precise order of events in liability disputes. She wrote something on her notepad. 4 hours later, Dr. Hargrove called me back into her office and slid a summary sheet across her desk. She told me my scores placed me in the above-average range for my age group across every domain tested. She said there was no clinical evidence of any cognitive impairment whatsoever, early stage or otherwise. She signed the certification herself, added the hospital seal, and told me the full report would be transmitted to my attorney within the hour. I drove back to Agnes's office. She already had the preliminary summary on her screen. She told me we were no longer playing defense. We were going to walk into probate court tomorrow morning with documentation that would not only defeat my son's guardianship petition, but would expose him to a formal elder financial abuse complaint with the County Adult Protective Services Office and potential referral to the district attorney. I asked her what our first move was. She told me to go home, eat a decent meal, and leave my back door locked. I did not follow the first instruction. I was not hungry. But I did lock the door. I sat in my small suite that evening and reviewed everything I had compiled over 14 months, the statements, the receipts I'd managed to photograph on my phone before they were thrown away, the text messages where my son referred to my account as the household fund, the birthday card for my granddaughter where she had written in her 7-year-old handwriting, "Thank you for the present, Grandpa, for a gift I had never chosen, never wrapped, and never known about until I saw the charge on my statement." I thought about the riding lawn mower sitting in their garage. I had purchased that mower. I had never once sat on it. I did not cry. I had done my crying in the months after Loretta died, alone in a 4-bedroom house, and I had run dry. What I felt sitting in that small room was something colder and much more useful. It was clarity. At 6:15 the next morning, my son knocked on my interior door. He was dressed neatly, briefcase in hand, the picture of a competent man managing a difficult family situation. He told me he was heading to the courthouse to file the petition and that I still had time to avoid all of this if I simply gave him the new account information and signed the power of attorney. I opened my door fully and handed him a single sheet of paper. It was a cover letter from Agnes Whitfield's office on her firm's letterhead, informing him that she represented me in all matters related to my finances and the state, that any further communication should be directed to her office, and that she would be present in probate court that morning with documentation that would form the basis of an elder financial abuse referral to the county DA if the guardianship petition was filed. My son read the letter twice. He folded it with careful, deliberate movements. He told me I was making a terrible mistake. He told me Agnes Whitfield was a predatory attorney who was going to drain my estate in legal fees. He told me he was only trying to protect me. I told him the document he was holding contained her direct office number and that he was welcome to discuss his concerns with her directly. He left without another word. Agnes was waiting on the courthouse steps when I arrived. She had a junior associate with her carrying 2 additional binders. The morning was cold and gray, and I was wearing my good overcoat, the one Loretta had given me for our 30th anniversary. I had not worn it since her funeral. It felt appropriate. My son arrived 12 minutes later. He was alone. He had hired a local attorney I did not recognize, a young man in a suit that was slightly too large for him. They conferred in quiet voices near the entrance. My son did not look at me. We were assigned to courtroom C on the second floor. The presiding judge was a woman in her mid-50s with close-cropped silver hair and a reputation, Agnes had told me, for having very little patience with what she privately referred to as inheritance harassment. My son's attorney presented the petition. He read the physician's letter into the record. He described a pattern of financial confusion and erratic behavior. He used words like diminished capacity and vulnerable adult. He asked the court to grant a temporary emergency guardianship order effective immediately. The judge listened without expression. When he finished, she looked at Agnes. Agnes stood up and submitted 3 items into evidence. The neuropsychological report from Dr. Hargrove. The certified bank statements with $41,000 in unauthorized transfers itemized by date and amount, and a sworn affidavit from me, notarized the previous afternoon, detailing the specific circumstances under which my son had obtained the physician's letter, including the date of the appointment, the name of the doctor, and the fact that I had not been present for the conversation in which my son described my alleged symptoms. Agnes then submitted a 4th document. It was a letter she had sent that morning to my primary care physician with a copy of Dr. Hargrove's full neuropsychological report attached, formally notifying him that his clinical notes had been used in a legal proceeding based on secondhand information provided by a party with a direct financial interest in the outcome. Agnes had requested that he review his notes and provide a supplemental statement. He had responded within 2 hours. His supplemental statement acknowledged that he had documented my son's concerns as reported concerns only, that he had not independently evaluated me for cognitive impairment, and that he had no clinical basis for a finding of diminished capacity. The judge read the supplemental statement slowly. She set it down and looked at my son's attorney over the top of her reading glasses. She told him she would not be issuing a temporary emergency order. She told him that the physician's letter, presented without its critical context, constituted a material misrepresentation to the court. She told him she was referring the matter to the County Adult Protective Services Office for investigation of alleged elder financial exploitation under state statute, and that she was forwarding her notes to the DA's office for review. She looked directly at my son. She told him that if he chose to refile, she strongly recommended he retain counsel with significantly more probate experience, and that he ensure any future filings contained complete and accurate information. She said the words, complete and accurate, very slowly. My son sat perfectly still. His young attorney was writing something on a legal pad with the focused intensity of a man who does not want to look up. The judge dismissed the petition. She gavelled the session closed. I walked out of the courthouse into the gray March morning and stood on the steps for a moment, breathing in the cold air. Agnes came up behind me and stood quietly beside me. She did not offer congratulations. She understood that winning in a courthouse does not feel like winning. It feels like surviving something you should never have had to survive. She told me APS would be in contact within 72 hours. She told me the DA referral was serious and that my son should expect a conversation with investigators. She told me she would be filing a civil recovery suit on my behalf for the $41,000 with interest. I thanked her and drove home. My son's truck was not in the driveway. The main house was quiet. Through the window of the in-law suite, I could see that someone had been inside. The small bookshelf where I kept Loretta's photographs had been disturbed. The frames were still there, but they had been moved, shuffled, as if someone had been looking behind them. I walked to my closet. The small fire safe I kept on the upper shelf was still locked, but the shelf itself had been pulled slightly away from the wall. I stood looking at that gap for a long moment. My son had been in my room while I was at the courthouse. He had not found what he was looking for because there was nothing to find. I did not keep cash at home. I did not keep bearer bonds or jewelry or anything that could be quickly liquidated. Loretta's engagement ring was in a safe deposit box at the credit union on Elm Street. The only things of significant value in that room were the photographs on the shelf, and those he had apparently decided were not worth taking. But knowing he had been inside my private space, moving through my things, looking for anything he could use or sell, removed the last trace of ambivalence I had been carrying. I sat on the edge of my bed and thought about my son as a boy. I thought about the drives to Little League practice and the science fair projects on the kitchen table and the hospital waiting room the night he broke his arm falling out of the oak tree in our backyard. I held those memories for about 30 seconds. Then I folded them up and put them away somewhere they would not interfere with what I had to do next. I called Agnes. I told her he had been in my room. She told me to document it in writing with time and date, and then to go look at his truck. I walked around to the side of the house where he usually parked. His truck was gone. His wife's car was still in the garage. I looked through the small window in the garage door. Her car was there. His riding equipment was there. And the space where he sometimes stored his trailer was empty. I called Agnes back. She said, "Good, let him run. He has nowhere to go." She was right. By the time my son came home that evening, the APS investigator had already made initial contact with both of us by phone. Agnes had filed the civil recovery complaint. My son's bank, alerted by the APS investigation, had flagged the joint account for review. His direct access to the account he had been drawing on for 14 months was suspended pending the investigation. He could not move money. He could not transfer assets. He was standing in the same foundation I had been standing in 14 months ago, except his was cracking from the inside. He came to my door that night. He did not knock hard. He knocked the way you knock when you are hoping someone will not answer. I answered. He looked like he had aged a decade since that morning. The careful presentation was gone. He was in a sweatshirt, unshaved, standing on my small concrete step with his hands in his pockets. He told me he wanted to talk. He said he thought things had gotten out of hand. He said he wanted to explain his side. I did not invite him in. I asked him one question. I asked him whether his wife had known about the physician's letter, whether she had sat in on that conversation with my doctor, or whether that was something he had arranged on his own. He was quiet for a long moment. He said she knew he had talked to the doctor. He said she thought it was just a wellness check. I told him to retain an attorney. I told him the civil suit would proceed and that he should not contact me outside of formal legal channels. I told him the APS investigation would run its course and that the outcome of that investigation was outside my control or his. He stood on my step for another moment. He said my name once, the way he had said it when he was 12 years old and had broken something he was not supposed to touch. Then he turned and walked back across the yard. His wife filed for divorce 3 weeks later. Agnes told me this was not uncommon. When the financial structure holding a household together is built on someone else's income, and that income disappears, the whole architecture collapses quickly. She did not say this with any satisfaction. She said it the way you say a factual thing. The civil recovery process took 7 months. My son did not contest the amount. I suspect his attorney told him that contesting it in front of a judge who had already referred the matter to the DA would be a poor strategic decision. He agreed to a structured repayment plan. The first payment came in on the Thursday, direct deposited to my private account at the credit union on Elm Street. I looked at the notification on my phone for a long time. I had already moved out of the in-law suite by then. I had found a 2-bedroom rental on a quiet street 4 miles away. It was a single-story house with a small yard and a detached garage and a front porch with 2 chairs on it, even though at that point I only needed one. I planted tomatoes in May, not because I particularly wanted tomatoes, but because Loretta had always grown them, and I had always been the one to build the wire cages for the plants. And it turned out that building small wire cages for tomato plants is a reasonable thing to do with your hands when your mind is processing a lot. The APS investigation resulted in a formal finding of elder financial exploitation. The DA's office declined to pursue criminal charges, which Agnes said was unfortunately common in cases without direct evidence of forgery or fraud. Just a pattern of unauthorized access by a family member. She said civil recovery and the formal finding on record were meaningful outcomes even without prosecution. I believed her. I chose to believe her. I do not see my son. I sent birthday cards to my grandchildren through Agnes's office address, since I do not want my personal address shared, and I include a handwritten note in each one because they did not choose their parents and they are not responsible for what their father did. My daughter-in-law, whatever else she was, always made sure the children called me on my birthday. That has stopped. I missed those phone calls more than I expected to. This past September, I drove to the coast for a week. I rented a small cabin outside of Cannon Beach, Oregon. The kind of place where the fog sits on the water until noon and the only sound at night is the ocean. I brought 3 books, a bottle of decent bourbon, and a photograph of Loretta from our trip to Acadia National Park in 2009, the one where she is standing on the rocks laughing at something I had said that I cannot remember anymore. I sat on the porch of that cabin on the 4th evening and drank 1 glass of bourbon and watched the Pacific go dark. I thought about the morning in March when I had handed my son a letter on law firm letterhead and watched his prepared narrative come apart in his hands. I thought about the courthouse steps and the cold gray air. I thought about Loretta, who had always said I was too quiet about things that bothered me, that I processed instead of spoke, that I let things accumulate until they became structural problems. She was right about that. She was right about most things. But I had processed this one correctly. I had let it accumulate just long enough to build an airtight case, and then I had spoken exactly as loudly as the situation required. There are people who will tell you that family deserves unlimited grace, that you should forgive because blood is permanent. I spent 64 years believing a version of that. What I understand now is that love without accountability is not love. It is an arrangement that benefits whoever is willing to take the most. When you stop subsidizing that arrangement, you find out very quickly what was real and what was just a function of your usefulness. I am not bitter. I am clear. There is a difference, and the difference matters more than almost anything I can think of. If any part of this story sounds like your life, leave a comment below. I read everyone. Hit the subscribe button if you believe that a man's retirement belongs to the man who earned it. And if someone in your life is treating your kindness like a bank account, trust what you are seeing. You are not confused. You are just hoping you are wrong. Sometimes the most important thing you can do for yourself is stop hoping that and start documenting it instead. I keep coming back to the moment I sat at that kitchen table with my coffee going cold and watched my son read Agnes's letter for the 2nd time. He folded it with such careful, deliberate movements. Like if he folded it neatly enough, the words inside would rearrange themselves into something more favorable. They did not. What I understand now, looking back at all of it, is that what happened to me was not a sudden betrayal. It was a slow erosion, and erosion only works on things that stay still and stay quiet. I had been very still and very quiet for 14 months. I had been processing instead of speaking, the way Loretta always said I did. But this time, the processing produced something. It produced $41,000 in documented evidence and a certified neuropsychological report and a letter on law firm letterhead. The silence had not been weakness. It had been the work. My son made a choice that I think he had been making in smaller ways for years before it became something a court had to look at. He looked at my retirement, at the steady monthly deposits, at the quiet old man in the in-law suite, and he decided that the gap between what I needed and what was coming in was there for the taking. That is a moral failure, not a mistake, not a miscommunication, not a generational misunderstanding about how money works in a family. A choice, made repeatedly, to take from someone who trusted you because you calculated that person would not fight back. He calculated wrong, and the reason he calculated wrong is that he mistook my patience for incapacity. He heard me being quiet and heard diminished capacity. He watched me defer on small things, the grocery choices, the streaming charges, the lawnmower I never rode, and he read deference as confusion. A man who had spent 30 years reconstructing the exact sequence of events in liability disputes. A man who had testified as an expert witness in 11 separate courtrooms does not forget what he signed and what he did not sign. He just waits until the record is complete before he acts. That is something I want to say plainly for anyone who is watching this and recognizes their own life in some part of my story. Your clarity is not diminished because someone who benefits from your confusion insists that it is. The most dangerous thing they can tell you is that you are not remembering correctly, that you agreed to things you did not agree to, that your concern is paranoia. Trust your documentation. Write things down. Date them. Keep them somewhere they cannot be found by the person you are documenting. The 3 things that carried me through were simple and not dramatic. I had been honest my whole working life, which meant I already knew the difference between a legitimate claim and a fabricated one. I had kept my mind sharp, not because I was preparing for a fight, but because staying mentally engaged had always been how I moved through the world. And when the moment came, I did not collapse into grief or into the easier path of handing over the account number and going back to my soup cans. I got up at 7:15 on a cold March morning and drove to a lawyer's office and sat down and told the truth to someone who knew what to do with it. What my son gave up to take $41,000 from me was the only thing I had left to give him freely. I do not think he understood that until it was already gone. I think about that sometimes, not with bitterness, but with the particular sadness of a man who built wire cages for tomato plants he would never get to eat. You raise a child hoping to build something that lasts. Sometimes you find out the foundation was never as solid as you thought. When that happens, you do not rebuild on the same ground. You find a new lot. You pour a clean foundation, and you start again. That is not giving up. That is just good engineering.